Military courts are working in 35 countries all over the world. Every country has a military law.
True.
The military courts trial by the civilians, by the military courts, they are not prohibited under the law or the constitution. I mean, you can't intervene into the internal affairs of another sovereign country. And if you are intervening on the sovereignty of another country, it means you are also violating the international law.
So, United States, United Kingdom, and EU openly committed violation of international law.
They are intervening into the sovereignty of Pakistan. They are intervening into a judicial system of Pakistan.
True.
They are intervening to a certain areas, which is the Army Act.
True.
It is protected under the Constitution of Pakistan.
European Union has been made on state of Pakistan. So we have seen silence on the part of the government.
I think the government should be proactive.
Bismillahirrahmanirrahim. Hello and welcome to Program Insight in V News English. Recently, Pakistani military courts awarded sentences to 25 those political activists who were violently involved in 9th May 2023 incidents. In these incidents, military installations, offices, state properties were attacked on the behest of a particular political party in Pakistan. So soon after announcement of and delivery of these verdicts by Pakistani military courts, European Union, United Kingdom, and United States expressed deep concern. And this similar stance in these all three regions, United States, UK, and European Union, says that these trials conducted by military courts lacks transparency. So rather, these trials should have been made public. And Pakistan, in the statements made by United States, United Kingdom, and European Union, the similar thing in the three statements that these trials must be made public and the trials must be fair. To discuss this, whether this trial was fair or unfair, or whether these trials were conducted in accordance with Pakistani law and Pakistani constitution, to dispel this all misunderstanding and misperception which these three countries are creating, we are today joined by Hafiz Ahsan Ahmad Khokhar, Senior Advocate, Supreme Court of Pakistan. He's not only a Senior Advocate, also a Senior Legal Analyst. Hafiz Ahsan Ahmad Khokhar sir, very warm welcome to our program.
Thank you so much.
Similar things in United States, United Kingdom, and EU says that these trials and these punishments lacks transparency. So how come transparency was there? If you look into the statement which was issued by Inter-Services Public Relations explaining these all things, they said due process of law was followed and due legal assistance was given to every convict.
Bismillahirrahmanirrahim. Mateen, you have pointed out the three statements given, one by the European Union, one by the State Department of USA,
and Foreign Office of
and the
Britain.
Foreign Office of the
UK
government. So four words are similar in these three statements. One is the due process.
Exactly.
Second
Transparency.
is the lack of transparency. Third is the judicial independence. And fourth is the due process of law.
Exactly.
So the military trials in Pakistan to the civilians is not a new phenomena in Pakistan.
This has been happening in the past.
The amendment was introduced in Pakistan Army Act in 1967. And who are the civilians actually? Basically, this is now a question. The civilians are those which are those who are civil employees in Pakistan Army. Those who are civilians working.
This is the definition.
This is the definition. This is the definition of a civilian. And those who are civilians working in the intelligence agencies of Pakistan. The third are those civilians who are the retired army officials.
Okay.
The fourth are the foreign enemies like the Indians, like Gulbhushan
caught
Singh,
in Pakistan.
who came to Pakistan and fought against the state institutions and the militaries and involved in the terrorist activities. And finally, those civilians in Pakistan who are violating the Army Act or certain provisions in the Army law. So these are the civilians. So the first time the amendments was introduced in the Army Act 1967, and 3 amendments came into this law. One is the 2D1. Second is the 2D12, and the third was the Section 59(4) of the Pakistan Army Act. Primarily, those persons who are civilians and are not directly regular employees of the Pakistan Army, they can be tried and prosecuted under the Pakistan Army Act due to the 3 reasons.
Civilian employees.
Civilian employees, even the civilian. One, I mean, they are fighting against the Pakistan Army. They are involving in the mutiny, and I mean, working against the state interest. And the third is the official violation of the Official Secret Acts. So the first time these amendments were challenged into the Supreme Court of Pakistan. And before that, in 1973 Constitution, there is a protection of these 3 laws. One is the Pakistan Army Act, the Navy Ordinance, and the Pakistan Air Force Act. These are protected under the Constitution of Pakistan, and they have been included in Schedule 1 of the Constitution. So the first time the matter was brought to the Supreme Court of Pakistan, whether the civilians can be tried under the Pakistan Army Act and through the military courts, and the Supreme Court decided certain things. The Supreme Court decided, and this is a response to the statement of the European Union and the United States and the UK Foreign Office. The Supreme Court says that these amendments and the trials made under those civilians who violated the Pakistan Army Act or the Official Secret Act, it is not against the due process of law. It is not against the fundamental rights. It is not against the transparency. And it is in accordance with the Constitution, because there is a provision in the Constitution. There is no discrimination that if you are violating a specific law, then you are liable to be held to be prosecuted under the special law. Generally, the civilians are immune from the Pakistan Army Act. The Pakistan Army Act is not applicable everywhere in Pakistan. It applies
This is very important point. It is not applicable everywhere.
It is not applicable everywhere in Pakistan. It is not applicable to every citizen of Pakistan. It applies to those who have violated the Pakistan Army Act, whether, I mean, they are fighting against the Pakistan Army when the army is ongoing on the military operation. And the second is when they approached and they went on the certain notified areas of the Pakistan Army and under the Pakistan Army Act, like the cantonments, like the public installations, like the intelligence agencies offices. So these who violated, I mean, they can be prosecuted. So from 1975 to onwards, Bateen, the Pakistani military courts have been trying those civilians who violated the Pakistan Army Act and who violated the Official Secret Act with reference to the Pakistan Army Act.
It's almost 50 years if you are talking
52 years.
52 years.
And then, I mean, simultaneously, the second judgment was, I mean, issued by the Supreme Court of Pakistan in 95 in the year 95, when the general, the wife of General, one of the General Shahida Abbasi, she directly approached to the Supreme Court of Pakistan and asking certain queries about the validity of the military trials. So
it was that Major General Zairul Islam Abbasi.
Zairul Islam Abbasi, he was involved in some conspiracy, and many of the other the army officials, they were involved, and some of them retired in the civil. So at that time, the Supreme Court again reiterated that the Army Act is a special law, and those who violated the special law, they can be prosecuted
applicable on them
because
only.
there is a procedure. I mean, there are certain special laws within in Pakistan. There is the ANF law in Pakistan. And interestingly, when in the tenure of Mian Nawaz Sharif, I mean, there was so many terrorist activities in Pakistan. Pakistan. And the first time the Pakistani government introduced Anti-Terrorism Act in 97, and there was a special court established. Again, these arguments at that time, which we are doing today, is that in view of the regular courts in Pakistan, why there is a special court of the anti-terrorism, and it is violation of the fundamental rights, and there are so many, the critics on the... Now, the special courts are working in Pakistan, and not in Pakistan, in 35 countries of the world.
Special courts.
The
military
courts are working in 35 countries all over the world, in different regions. In South America, in Asia, in the Central Asia, and in the GCC countries. The second important point is that every country has a military law.
True.
Either it is the United States, it is the UK. The other thing is the process of conducting a trial is quite different. Sometimes these countries have the special tribunals, and sometimes these countries have the military courts. And military courts, Mateen, is not the ultimate authority under the Pakistani Army Act.
The verdict could be challenged in the superior judiciary.
If, you have been prosecuted under the Army Act, by the military courts, and if your sentence is confirmed, like in this particular cases, the sentences have been announced, and so far it has not been confirmed by the federal government or the Chief of Army Staff. If these sentences are confirmed, then there is a right of appeal available under the Pakistani Army Act.
Within this forum.
Within this forum, and Section 133B of the Pakistan Army Act is available. And if you are not satisfied with the appeal decisions, you can go to the High Court of Pakistan under Article 199 of the Constitution. The decision could be challenged, and it is decided in 1975 of the Supreme Court that if you are aggrieved by the decision of the military courts, you can approach to the High Court. Then there is another forum. The another forum is the Supreme Court of Pakistan. You can file an appeal against the order of the High Court to the Supreme Court of Pakistan under Article 185 of the Constitution. If further you are not satisfied with the decision of the Supreme Court, then you can file a review petition under Article 188 of the Constitution. So there are 5 forums available. At the trial stage, the accused has a right to represent his own choice counsels. His family can visit the trial proceedings. He has a right under all available under the Criminal Procedure Code. The Kanun-e-Shahadat order. This is available to them. He has a right to cross-examine. He can bring the witnesses for him, and he can make the statement why the case has been registered against him under Section 342 of the Criminal Procedures Code. So to the extent of the trial process, the regular trial and the trial under the military laws is the same. The only difference is the trial is conducted by the military authorities, like the brigadier in the field, General Court Martial, and then there is a speedy manner in the the military courts. So if we evaluate or examine, the law in the Constitution, now the situation is that because of the incident at the 9th of May in Pakistan, and there was a mob, 62 buildings or the government installations, and
were ransacked and burned.
The installations of the Pakistani army or intelligences, and these were the notified areas. If you violate, you can be tried and prosecuted under the Pakistani Army Acts. So billions of rupees loss to the nation. And finally, the controversy starts when a direct petition was filed under Article 184(3) of the Constitution of Pakistan, and Supreme Court took the cognizance and started proceedings. And then there was the understanding or the undertaking by the Attorney General Office that the trial will not be concluded until the decision will be announced by the Supreme Court of Pakistan. And interestingly, Mateen, being a student of law, if you challenge one time a certain law on the grounds of the vires of the Constitution, and if the Supreme Court decides something that you can't again go to the Supreme Court Court again challenged the vagaries of the law. The vagaries of the law of the Army Act Amendment challenged in 1975. Supreme Court decided in 75 all the points of the due process of law, transparency, fair trial, and the access to justice. So this practice was continuing in more than 50 years. And interestingly, in 2023, on the 23rd October, Supreme Court decided retrospectively that the amendment made in 1967, these were the unconstitutional and they was not against, in accordance with the law. And
that's very good. So our law has also been quoted, International Covenant on Civil and Political Rights, to which Pakistan is also a signatory. In a statement made by European Union and United Kingdom and United States that Pakistan is a signatory to this law, and this international law guarantees a fair trial or open trial. So how would you like to comment on this international law that in these three statements, this has been frequently quoted? Your response?
Actually, before going on that,
please.
That the judgment passed by the Pakistani Supreme Court on 23rd October was 4-1, and the dissenting view of the present Chief Justice of Pakistan, and he write on it that if the Supreme Court already decided by the 5 members bench, then we should restrain for issuing an order.
23rd of December.
23rd of October. 23rd of October.
Recently.
And this was and then on the 13th December 2023, the judgment was suspended. And now the sentences has been announced in pursuance of the direction of the Supreme Court of Pakistan. If there is any illegality, I mean, the announcement of the judgment or in the trial, the Supreme Court should have asked the military authorities that you should not conduct the trials, meaning thereby, if our practice has been followed for the last more than 50 years, and there was no, the debate on it about the military trials by the civilians under the military courts, it was happening in the PMLN government. It was happening in PTI. 25 people were, tried by the military courts. And then there was...
And the then Prime Minister justified it. Exactly.
And he went on so many times. His cabinet ministers went on so many times. And they identified and they highlighted the value of the military courts. Now come to the point on...
International law.
International law. The international law, in addition to the international law, your constitution also grants the Article 10A, the fair trial and the due process of law. So it's not a new phenomenon for Pakistan. And the International Convention, which is a signatory, the Pakistan is a signatory, it doesn't prohibit your special law process. It only emphasizes that it should be transparent, there should be a due process of law, and there should be no, the discrimination, and there should be a fair treatment. So in our country, in this particular case is that all these points which are now agitating by the European Union, by the UK and the United States have been identified and addressed by the highest Constitutional Court of the Pakistan in 1975, and it keeps saying on it that the military courts trial by the civilians, by the military courts, they are not prohibited under the law or the constitution. Now come to the second point on this, that because this was a political move, many political activists, they approached to the certain notified areas, they involved in these commission of offenses, and there is a forensic evidence available.
Forensic evidence is available.
There are some of them, they commission of offenses, they confessed. Some of them have uploaded their pictures while approaching there, destroying to the social media, Facebook. It is an evidence. And it is admissible under the Qanun-e-Shahadat order. So in all these particular areas that you are there, evidence is there, corroboration is there, forensic evidence is there, geofencing is there, and you are violating the Army Act, and the process is military courts. So I think the statement made by these countries, I think it is in the violation of the international law. they are, intervening.
They themselves have committed
international law, you can't, intervene into the affairs of another country.
Exactly.
If
Wonderful.
you don't have a legal justification, you can't intervene into the internal affairs of another sovereign country.
True.
And if you are intervening on the sovereignty of another country, it means you are also violating the international law.
So, United States, United Kingdom, and EU openly committed violation of international law.
They are intervening into the sovereignty of Pakistan. They are intervening into a judicial system of Pakistan.
True.
They are intervening to a certain areas, which is the Army Act.
True.
It is protected under the Constitution of Pakistan, and the highest authority of the Supreme Court of Pakistan. They're deciding the cases on the civilians. Sometimes they confirm, sometimes they set aside the judgments of the military courts, but it keeps happening. So where are these countries and these political parties who came now and saying that the civilians should not be tried under by the military courts? So this practice is not a new one. The Army Act is not amended in 2024. The military courts are not established in 2024. The Supreme Court is not saying yet that the civilians can't be tried under the military court. So I think it is the statement made by these countries or the European Union. It is for the public optics. It is only for the public. They knew until unless there is a Mateen violation of our constitution, our judicial system, then you can say that you don't have been given a right of fair trial.
So a quick political question. So due to these statements, do you think there is a pressure on Pakistan, and will Pakistan will reverse these things?
I don't think so.
It will not be reversed.
No, I don't think so, because this is not a new law. A new law, you can say it could be persecuted. A law which is, amended in 1965 and practiced in the country for the last more than 60 years, upheld by the Constitution Courts of Pakistan, the High Courts and the Supreme Court, and suddenly you are saying that a trial conducted by the military court is against the transparency or is not a due process of law. And more importantly, when these verdicts will be challenged, can be challenged before the High Court and the Supreme Court of Pakistan, and they have the authority under the Constitution and law to either accept or either to reject the sentences of the accused. And I'm giving one example more.
Please.
You are talking about the international law and convention. Gulbhushan came to Pakistan. He involved in
subversive activities,
killing people in Pakistan. He was tried because he was a civilian. He was tried under the Army Act by the military court authorities, and the Indians went to International Court of Justice to challenge
Pakistan didn't go there.
To challenge the process of the military courts.
True.
And the International Court of Justice, they said that you can provide the independent appellate forum to this gentleman, but they have not set aside the process of the military court. So if there is an issue with the process of the military courts in Pakistan, ICJ can comment on it, the transparency, the fairness, and the due process. And the second important thing in this context the whole story is that until unless the parliament revoked this law, or the Supreme Court annulled the amendments made in 1967, it is the law of the land. It is the law of land, and if there is a law of land, whatever the procedure has been prescribed in the law, it has to be followed. And if it is to be followed, then it means it is not unconstitutional, it is not illegal. And whosoever would be, if a politician, a political worker, or a person who is not a political worker, if he comes within the ambit of the violation of the Army Act or the official of secret act, irrespective of the status of that gentleman, he can be tried, he can be prosecuted, he can be sentenced under the military courts, and the Pakistani courts have the authority to have a judicial review over that exercise. So to this conclusion, I must say that these countries should have avoided to make any statement within the internal affairs of Pakistan. And if this is happening from 1967 to onwards, you have not seen a single statement by the US authorities or by the European Union or by the UK Foreign Office that the military court's trial is against the transparency, is against the due process of law, and the right of fair trial should be given. So I say that the sentences have been announced in pursuance of the direction of the Honorable Supreme Court of Pakistan. Still the matter is pending there. If the Supreme Court decided otherwise, so these sentences or the trials would have been transferred to the anti-terrorism court. And on the other side, if Pakistani Supreme Courts annulled the judgment of the 23rd of October by the 5 members, because at the moment there are 7 members bench, they are hearing the case. If they reject or set aside the 23rd October, the law of land would be that any person who is a civilian, directly not under working the umbrella of the Pakistan military, Air Force or Navy, if he violates any provision of the Army Act or the Official Secret Act, he can be prosecuted by the military authorities under the military courts. And if he is aggrieved by the orders, he can challenge the sentence before the Internal Appellate Forum or can come to the High Court or the Supreme Court of Pakistan. And this is the law and this is the constitution.
Last, we are heading to the conclusion of the program. You are speaking as an independent legal analyst. Why there is silence on the part of the government? The attack by the United States, United Kingdom and European Union has been made on state of Pakistan. So we have seen silence on the part of the government.
I think the government should be proactive. If some country has a made statement about your judicial system of Pakistan, because military court system is now the part of judicial system of Pakistan. Because there are so many, the special courts and every special court and every process which is validated by the parliament or approved by the Supreme Court of Pakistan, it is the law of land. And if some country speaks on it and he says that might be it is not against the due process or it is against the transparency, the government should come first. All the ministers should make their statement. The Foreign Office should set clearly in words that it is the interruption or intervention in the internal affairs of Pakistan. And I believe that in 1 or 2 days, the statement from all the ministers who are the relevant minister, they should come on and they should say what the law and what the constitution is.
Thank you so much indeed on this very important and urgent issue that the statement made by United States, United Kingdom, UK, and the statement made by European Union was of extremely serious nature. And as you said, it was a direct interference into Pakistan's judicial matter, Pakistan's internal political affairs. And on this sensitive matter, despite your busy schedule, you participated in our program.
It's my honor.
Dear viewers, till our next program, goodbye and Allah Hafiz from studios.